SJC-11815, Commonwealth v. Tyrone J. Clark.
Good morning. May it please the Court, my name is Neil Raphael and I represent Tyrone Clark in this matter. Mr. Clark was convicted in 1974 for rape, robbery, and kidnapping. Throughout the trial and for approximately 40 years after his conviction, Mr. Clark has maintained his innocence.
I take it that what you are seeking is a determination as to whether there is blood on the knife handle.
No, I am seeking a DNA analysis to determine whether or not there's forensic evidence or biological material on the knife handle.
Well, but you sort of conceded.
Knife handle.
Yeah.
There's a knife handle and there's a portion of the blade. If you look at the picture, there's a portion of the blade.
But you'll concede, will you not, that touch evidence would be really unusable at this point?
I'm not going to concede that. At the initial hearing,
I thought you had already conceded.
I stated that at the second hearing that I thought that because of the time lapse, that touch evidence would not be on this piece of evidence.
And no way to assess how many people had touched this piece of evidence over the 40 years.
I never conceded that. I never said that there was an issue with respect to how many people touched the evidence. My concession at the hearing was that I was under the misconception that because of the duration of the time between the conviction and the sentencing or between the conviction and the 278A motion, that touch DNA may not exist. But to be candid with you, lawyers and judges should not be in the position of determining whether or not DNA evidence exists under this statute. That's the role of a forensic laboratory who has trained technicians to make that determination. Judges and lawyers should not be making a factual determination as to whether or not physical biological evidence still exists. I should not have made that statement at the hearing. In the same token, the Judge Connor should not be making a determination as to whether or not there's blood evidence on the knife handle.
Well, I mean, you've got to make some demonstration that the evidence would be relevant and of some import. And touch evidence 40 years later on a piece of evidence that has not been sealed or protected from any number of touches, including touches by members of this court 40 years ago when the evidence comes here for review. I mean, that seems like you don't have a prayer of making the argument that that's a basis to go forward here. Blood evidence, on the other hand, I don't think too many other people have been bleeding on the knife.
Right, I don't think anybody else would blood on the knife, and that's why initially I said I wanted blood evidence. But with respect to the issue of touch DNA, there's nothing in the record, there's no factual finding by any court that this knife was handled in a corrupt or has been corrupted over 40 years. Except,
for example, when the district attorney found it, it just fell out of the envelope and she grabbed it. Like, maybe members of the jury would have touched it in the jury room. I mean, I'm sure the prosecutor wasn't wearing gloves when he passed it around or when he offered it into evidence, or the detectives or anybody else.
I do not know how they handled it 40 years ago. There's nothing in the record to indicate that. You are correct that ADA Panalano mishandled the knife when she grabbed it. But in my motion, I saw Y chromosome DNA testing for that specific purpose.
No, I don't know about mishandled, but even if people have mishandled, I don't know what your expert said about this, because I know that your initial view was to look for blood evidence. Are you suggesting that, notwithstanding that there may have been some individuals, such as today, who inadvertently handled because of the way it was kept, that nonetheless, the point would be, if there is at all touch evidence, you could discriminate whose DNA touched the handle or not. If you can't, you can't. But if you can certainly say, well, that's hers, it wasn't hers, she didn't do it. But there's this other stuff left. Is that what you're arguing?
Correct.
But how can, I mean, talk about chain of custody problems. I don't think you can get over a chain of custody problem if what you're looking for is touch evidence.
With respect to the chain of custody, I cannot prove, and I can't prove that how this was handled 40 years ago. There's nothing I can demonstrate from the record. I'm stuck with the trial transcript. The DA can hypothesize that this was mishandled 40 years ago.
Not mishandled, not mishandled. It was handled. Why are you saying mishandled? 40 years ago, what do you think the standard was?
Well, there's still fingerprinting technology 40 years ago. So what I would suggest is I cannot establish how this was handled 40 years ago. I cannot establish that as a factual matter. But in the same token, I don't have to prove a negative. I don't have to prove it was not handled properly. There's nothing in the record that's going to be able to demonstrate how it was handled 40 years ago. There's no one around basically to ask how was this handled 40 years ago. The prosecuting attorney is dead. The trial judge is dead. So there's nobody in connection with this case can demonstrate how this was handled 40 years ago.
But
Is it your view that if the facts of this case were that the perpetrator grabbed a knife and threatened her with it, and that no blood was spilled, that you would still be entitled to this knife?
It is.
Purely because of touch?
Purely because of touch.
Okay.
But additionally, we have the fact that she tried to stab the assailant with the knife, and there's no indication in the record whether he bled on the knife or not. So as a result of that, the statute doesn't require me to show that there's actual blood evidence on the knife. All it requires me to show is that there's a nexus between the knife and the assailant who touched it.
Well, you
And
have to show that
clearly,
there's-
the trial transcript does show that here.
You have to show that there's a potential to result in evidence that is material, and the argument is there's a potential that although there was no evidence that blood arose from it, you're arguing essentially one can infer from the fact that she stabbed him and that the knife broke to indicate that there may be some blood on that knife.
Exactly. And the fact of the matter is,
Or attempted to stab him.
she attempted to stab him, and it's not clear whether his skin broke. But the statute does not require that I show that there's actual physical blood evidence on the knife. That's an impossible standard for defendants to meet, and it's not really the role of judges and lawyers to be hypothesizing when we have a lab who can make that determination in a matter of weeks rather than having months and months of hearings as to whether or not physical evidence exists on the knife.
Right, but certainly if there was no evidence that anybody had attempted to stab anybody, and put aside, let's assume that you did concede that touch DNA is not relevant, you wouldn't be able to get the knife without there being some allegation or some information to indicate that blood may have been spilled.
Right, there has to be some sort of nexus between the item that's being tested and the perpetrator. The judge at the trial level was expressing concern about every piece of furniture in the living room. If there's no indication that the perpetrator came into any contact with that piece of furniture, of course I would not be able to obtain testing of that item under 278A. But here there's a clear indication in the record that the perpetrator touched the knife and may have bled on the knife. And as a result of that, I should be able to obtain DNA testing under the clear language of the
Does
statute.
bleeding, does the result have to have been bleeding? If I get the right word, is it possible that there's some epithelial cell on the knife other than blood?
There is a possibility that there's skin cells or touch DNA on the cell. There may be a possibility that there's trace evidence on the knife.
On that score, though, it seems to me the issue is, of course, we don't know exactly how it was handled, but it is 40 years, and it was handled by a lot of people. I think we can assume that to be the fact. It went to trial, it was on appeal, it's been in the DA's office, et cetera. So isn't at the end of the line, it's a relevance question, because at the end of the line, assuming the best, obviously, from your perspective, is that there's no touch DNA. I'm just talking about touch right now. There's no touch DNA connected to your client, right? But what does that mean, given that it's had 40 years out there, being touched by tons of people?
For the purposes of 278A, I don't think it means much. For the purposes of a motion for new trial, it might mean a lot, but for the purposes of a 278 attempt to...
It might mean a lot in that it wouldn't give you is that what you're saying?
It wouldn't give me a lot in the context of a motion for new trial, but in the context of a motion for access to DNA evidence under 278A, it does not mean a lot, because the statute doesn't require that I show how probative this evidence is going to be, or...
So you can't think, it's not fair for the Commonwealth or the judge to be thinking about that at all?
No, it is not.
So there cannot, I take it you're saying then, that there cannot be a level of contamination that would make DNA testing of the handle of the knife as a practical matter absolutely fruitless. 200 people touch the knife. What kind of testing can be done?
Touch DNA evidence can still be gathered.
Yeah, for 200
people. If 200 people if there are 200 profiles of DNA evidence on that knife, and we obtain 200 profiles, we can compare it to my client, Mr. Clark. If it does not match Mr. Clark, it does have some evidentiary value. It may not have a lot, but it may have some value in the context of a motion for new trial. Now, for the purposes of 278A, the judge should not be making that determination. The purpose of 278A, he should just be making the determination whether or not to grant access at this point in time. It does not matter what the import of it is on a motion for new trial.
It matters a little. I mean, you've got to show potential to result in evidence that is material.
I have to show potential that is evidence that is material to the identification of the assailant. And the fact of the matter is if you have 200 profiles on a knife, and my client is not one of those 200 profiles, then that is material to the identification of the perpetrator. It may not be very material, but it is material.
It's also material, isn't it, if he is identified as one? I mean,
Absolutely.
it doesn't really speak to proving that he isn't. All it says is that it's relevant to who is the perpetrator. I think the contemplation here is that it would actually also clarify, oh, actually, looks like it was.
True.
Right?
And the fact of the matter is this is an African-American man convicted by a white woman of rape. The jury was all white. The judge was white. If I can show on DNA evidence that there's an African-American male on the knife and it does not match my client, that is very material as to the identity of the perpetrator.
Well, you've taken another step. Now you've said if you can show that there's an African-American DNA of an African-American man on that knife. Is that right? That's what you're looking for?
I'm looking to the DNA evidence. I should not have to, in order to access the evidence, guess what the evidence is going to show me. I should just be given access under 278. That's what was the intent of the legislature, was just to give access. It was not to make any determination as to whether or not it was going to be, how significant it was going to be, or whether it was going to result in a motion for new trial.
Preponderance of the evidence to show that it has the potential, the real potential, not the incredibly speculative, who knows what might happen potential, right?
No, the statute says potential, and it only, that subsection B4 only speaks to the identity of the perpetrator.
So, and if there are 3 African Americans who are in the chain of custody and perhaps one or two on the jury, they're all dead, what do we do?
Well, presumably, if I find that there's 2 African-American males or 3 African-American males and 2 of them are on the jury, I can track down their families and figure out where they were.
Well, they're not, because you just told us the jury was all white. But
Well, I'm sorry, I'm using his hypothetical. If in another case, I can make a determination, okay, where were you in 1974?
Do we know that the jury was all white in this case?
I don't believe there's anything in the record reflecting that the jury was all white, though I do believe that at some point in a motion for new trial, Mr. Clark indicated that. But in the record before the court, I don't believe there is anything.
Now, Judge Connors characterized the statute as providing for a reasonable possibility or reasonable potential. Do you agree?
No, the statute does not require
Do
reasonable.
you think it's a theoretical potential?
I don't think it's a theoretical potential either. I think it is just a question of whether or not there is a nexus between the individual or the perpetrator and the piece of evidence that is being sought to be tested. I don't believe
Well, the statute uses the word, Section 3, the potential to result in evidence that is material.
it is potential to be material, but it's not a theoretical possibility or a real possibility. The judges and juries and lawyers should not be making guesses as to whether or not there's physical evidence on a piece of a knife. There is a place where that should happen, and that is in a lab with an accredited technician.
But you just said that if there was no evidence, you just said that this does not speak to every piece of furniture in the apartment.
Right.
So there's some reasonableness element here.
There is the element is whether or not the individual came into any contact with the piece of evidence. And here there's a real indication that the individual came into contact with the knife. Whether he touched the knife, and then he may have bled on the knife. So there's a real indication that in the record that's all we have, that the assailant utilized the knife during the commission of the crime. And
so for you, the key is the physical contact of the knife with the person.
Right. And if we test this item, whether or not it's going to give us any information, it might be a small amount of information, but any information that is material as to the identity of the perpetrator. So whether it's a theoretical possibility or a real possibility, or however the court wants to, it's just any information. That's all it's seeking is information. That's the whole point of the statute, is to provide information to defendants.
Well, so you have, I mean, I don't know what then your burden is, preponderance of the evidence to show that it has the potential to produce touch evidence that might exonerate your client. I mean, let's leave blood evidence aside. I think they're very different. So you have to show by preponderance of the evidence, right? So what does that mean?
I think based on the statute, all I have to show is in the record, is there some indication that there was a nexus between the perpetrator and the piece of evidence being sought? Is it going to be probative of whether or not this was we got the right individual? That's all the statute
This is to get the hearing, or this is to get the testing?
This is to get the testing under subsection 7.
Okay.
May I speak briefly to the discovery issue? I know my time is running out. On the discovery issue.
1 minute.
Okay. On the discovery issue, Judge Connors committed clear legal error. He analyzed my discovery request under subsection 7B4. 7B4 is an inquiry as to whether or not DNA testing should go forward. I have never requested DNA testing on behalf of Mr. Clark under subsection 7B4. All I requested was some information as to what the socks were, where they were left, whether they exist.
I think the Commonwealth says they don't. They don't have them.
The Commonwealth also said the knife didn't exist in 2000. I've worked on the Innocence Project for 10 years, and in every single case that I've worked on, we've always been told that the evidence does not exist.
So what do you need beyond a statement that we've looked at everything and it doesn't exist? It's not in the file. It was never seized.
I would like the opportunity. Well, no, it was seized.
Not the cloth. It was two things.
I'm talking about the socks. The socks were seized, and for the purposes of appeal, I've only appealed the issue of the socks.
And not admitted into evidence?
They were not admitted into evidence, but with respect to the socks, I should have the opportunity to inspect their offices. That's all I'm seeking.
Inspect the district attorney's offices?
Correct, because there have been numerous times where law clerks or law student interns have been able to go into either a courtroom or some place where physical evidence is kept and discovered when they've been told that for years that the evidence does not exist. In this case is a perfect example. We were told the knife did not exist.
All right, thank you.
Thank you.
Good morning, Your Honors. If it please the Court, Donna Petalano on behalf of the Commonwealth. Sitting with me at council table is Larissa Warren, a Boston College second-year law student who has worked on this case with me and is a member of the Boston College Innocence Program.
So if there's blood on this knife, isn't that really important?
That is really important, Your Honor, but that isn't the only thing that has to be shown. He didn't show that, first of all, but even if you look at the record to say, in a light most favorable to the defendant, looking at the record that there may be blood evidence on this knife handle, there are other things that have to be shown. And Judge Connors asked him at the hearing, what about contamination? What about, here's one thing, it was dusted for fingerprints. It's in the record. It's at the transcript 293. How does dusting of fingerprints in 1973 affect the blood evidence?
I don't know the answer to that,
Neither
but isn't
do
that
I.
exactly the kind of thing that a lab might be able to sort out? I
Yes,
mean, blood
but-
evidence is different than touch evidence.
Your Honor, though, the burden is on the defendant.
Are we talking about
and-
3 or 7 at the moment?
Well, we actually looked at it under Section 3 to give the benefit of the doubt to the defendant because he didn't even meet...
much lesser burden.
Absolutely, and he didn't even meet Section 3 here, but the judge gave him a hearing, in fact, 2 hearings, never requested an evidentiary hearing, but that's why Section 3 provides for affidavits. Nobody has to guess here. Nobody, the legislature is not asking the judge to guess. The legislature provided for the defendant to give affidavits that talk about contamination, that talk about how it was handled, could it have deteriorated,
You've had it. How's he supposed to know that?
Well, he doesn't necessarily have to know that, but he has an affidavit from Professor Cotton that doesn't talk at all about what happens. It's very difficult, first of all, for me to separate the touch DNA from the blood because this entire record below was on blood evidence. There was absolutely nothing, and at a record appendix
Let's
231...
focus on blood. How is he supposed to know,
He doesn't
since you've had it, about contamination?
Absolutely, Your Honor. He doesn't necessarily have to know, but then you need to have somebody who says, okay, he knows it's wood and he knows it's blood. Have an affidavit that says if blood is deposited on wood in the course of 40 years, even in perfect conditions, this is what is left. And this is what we can do. This is how we screen for blood evidence, for occult blood evidence. Is it destructive screening? Nothing in the record. In fact, if you look at the record, Professor Cotton's affidavit doesn't even mention the word blood once. And neither does the first filing by the defendant. It isn't until after our response. And in fact, there's an email in there from me in 2012 saying, please, what lab, what kind of testing do you want? What kind of screening do you want? Tell us what the relevance is so we can move forward on this. And the same thing in the transcript at the hearing. You know, I'm very fortunate to work for a district attorney who is extremely forward-looking when it comes to DNA testing. We do DNA testing all the time, but we need to know what's going to happen, especially when we hear there's a waiver of touch DNA evidence. Well, would the screening for occult blood destroy that touch DNA evidence? Is that something we want to do? Shouldn't the judge know that? And it's not a guess that the judge has to make. All the defendant needs to do is submit an affidavit that explains what is the screening process and what is the test that he's looking for. He's talking about the results in his filing, but he doesn't talk about how they do it, what lab to go to. These aren't heavy, heavy questions that the judge needs to know the answer to before he can move forward. If you look at now, if you move to Section 7, there's a reason why there is that subsection 2 in Section 7. It's because there needs to be some information that this evidence is going to be relevant. You know, we need to know, would it lack any probative value? And all of that information that you are able to get and submit into an affidavit should be before this judge when he makes the determination.
So if there is an affidavit that says, or to the effect that even if 200 people have touched it, and even if there were, if it had been dusted for fingerprints, there still is a remote possibility, a very slight remote possibility, that there could be touch DNA that could identify the perpetrator.
Or blood evidence.
Well, the standard is the preponderance of the evidence under Section 7 that the judge would have to find. But even if you go under Wade and say, you know, would be, use the would be, you know, that there could be evidence on that blood, then I think the judge is legally correct to order testing on that knife handle. We're
help me a little bit, okay? Let's take it step by step, okay?
Okay.
Let's do you think that there is, given the fact that the victim said that she attempted to stab him with a knife, and I couldn't tell, was it a butter knife or was it a
Bread, I think.
It's a bread. She
bread
described
knife?
it as a bread knife.
So it's serrated and sharp. It's
yes.
not. It's not a
In
butter.
fact, the Exhibit 3 is she drew a picture of what the blade looked like.
Okay, so it is a knife that cuts.
Yes.
She says she attempted to stab him, and apparently whatever she did was with enough force to break the blade.
Yes.
Okay, so do you agree that there's a reasonable possibility that she may have shed some blood of the perpetrator?
Interestingly, when you look at the transcript, I don't necessarily agree, Your Honor, but I would say, give the defendant the benefit of the doubt and say that there was blood evidence on the knife blade. Then there's a question about whether you can say it would end up on the knife handle. Even give him the benefit of the doubt that there's blood evidence on the knife handle. You still have to go to those questions about the chain of custody. The chain of custody is in there for a reason. It's not you need to tell us, defendant, exactly where this knife handle was from 1973 to 2004 when unfortunately it landed on my desk. And, you know, I apologize. I have apologized to the defendant. I looked at the box before I read the transcript and really didn't understand the significance of that knife handle when I opened that box. And when I read the transcript, I was heartbroken that I had touched this knife handle, even in a day and age when we didn't really understand touch DNA, because that was back in 2004. Certainly I didn't understand touch DNA at that point.
But again, maybe I'm missing something. How is the defendant supposed to know anything about the chain of custody between 1973 and 2004?
Well, first of all, he knows that it's been dusted for fingerprints. Yeah. He knows that it's been touched. And Mr. Clark was certainly in the courtroom when the knife handle was introduced into the exhibit. I noticed from the docket, I'm not sure that you have the trial transcript, but when you read the trial transcript and the testimony of the victim, it's a very fair inference to draw that the prosecutor is holding the knife handle. In closing,
All right, so let's assume all of those things.
and closing, the defense counsel holds the knife handle and says to the jurors, "You'll have this when you're back in the jury room. Look at this." He's inviting them to touch it.
Okay.
So what?
We're on blood now. We're
Okay.
talking about blood.
Are we still talking about blood, Your Honor? So does blood evidence, when it is on a porous surface like wood, does it deteriorate over 40 years? Even under perfect circumstances, let's say that this was held in perfect circumstances. We don't know. The best guess that we can draw is that we received it back from the clerk's office in 1981. I submitted a motion to the court with the pictures of the exhibits, and there's an envelope that the knife handle was held into, and it says, "This is to be saved per order of Tom Mundy, who was the trial prosecutor, and dated 6/8/81." So I think it's fair to say that we came back into custody of this in 1981, but have Professor Cotton, he has an expert, say, this is what happens when blood is deposited on a porous surface. This is how long the basic life is of that type of blood evidence.
You think all of that is knowable in advance?
Excuse me?
All of that is knowable in advance. I mean, there's something about this that just strikes me that the easiest answer to the question is to just have the knife handle tested.
Well, not necessarily, Your Honor. What if we tested for blood evidence here, and that testing was destructive of the touch DNA?
Suppose that's the DNA. Suppose the defendant says fine. Let's have it tested for blood evidence, even if it means destroying touch evidence.
I'm not sure we would agree to that. I think we would want to do the touch DNA first before we would do the blood evidence.
You want to do testing,
but that certainly isn't what happened.
You want to do testing as well as having the defendant allowed to do testing?
I'm sorry, Your Honor.
I'm sorry. I didn't understand that you wanted to do testing as well as having the defendant do testing.
Well, there are times when we do testing, when we go and we do testing without having requests from as part of our conviction integrity program, where we have testing without requests of the defendant.
Why isn't Robin Cotton's affidavit enough? She says there may be touch DNA on the handle that could be tested.
Because he said at the hearing, we're not talking about touch DNA, we're talking about blood evidence.
What if he hadn't said that?
Yeah.
What if he hadn't said that? I think she would still need to say, for example, the very clear example is when you're dusting for fingerprints, is that destructive of touch DNA? That would certainly tell us that any of the DNA that's deposited was after that was dusted for fingerprints in June of 1973.
Do you think the judge should have, did I get it right that when the defendant was arrested, he was checked and there were no injuries on his person consistent with having been stabbed with a knife? Do you think the judge should have given some consideration to that in deciding whether or not this blood evidence should be pursued?
No, Your Honor, because it's a claim of actual innocence, so he is saying he wasn't the perpetrator, so there's no way he would be able to have a knife wound in the back. I will say, though, interestingly, at the trial, the stabbing or
do I have it wrong? Wait, I thought he didn't have any injuries.
He did not have any injuries.
Did not.
I'm sorry if I misspoke. He did not have any injuries.
Okay.
In fact, that was a point that was actually drawn out at the trial. The defense counsel, in arguing in closing, said, there were no.
I get
there
that.
Were no evidence.
What I'm asking is, why isn't that a factor in the judge's consideration?
I do think it is, and I think, and so I say to this court, let's, maybe the standard could be you could look at the record evidence in a light most favorable to the defendant if there is biological material on the object that they want to be tested. But even here, you still don't get to the testing because there's not enough showing under 3B and 7B that the evidence didn't deteriorate. Judge Connors said, what about contamination? Deterioration is certainly it's in the statute for a reason. There has to be a showing. And the judge can't order testing. It says shall order testing unless all of those subsections are
Well,
met.
isn't this the kind of case, though, that prompted this law?
Yes, it is, and the burden is not onerous, though, Your Honor, to get an affidavit that says, and in fact, if he had gotten an affidavit, I don't think he would have waived the touch DNA claim here. And it's wonderful that under 278A, whatever decision this court makes, the next day he can go and file a new 278A with the appropriate record so the judge can make the right decision.
So you say that Robin Cotton's affidavit did not address the question of dusting for fingerprints. Okay, so now he gets an affidavit, comes back and says, even if there were dusting for fingerprints, then your response is, well, you didn't take into consideration the humidity that was in the DA's office for the last 40 years. And so then they go back and they do that. So 20 years down the road, he's gotten affidavits that have addressed all of your concerns because you've run out of them.
No, Your Honor.
But why don't we leave those issues for cross-examination?
But that's why it's just a preponderance of the evidence. We're not asking for that much here, but we just need to know there was nothing. When you look at the first filing, all it is a heading that says there is we don't know what the chain of custody is. There's nothing about deterioration. There's nothing about contamination. There has to be something. The legislature, has put in place.
Because, as you're suggesting, this doesn't end. He can go back.
Yes.
So we're really writing about what are the steps
Yes.
and whether these were enough or not.
Yes.
And aren't you suggesting that really all that can be said at this point, without having anybody had a chance to do the kind of testing that they want to do, is that there is a possibility that even though it's been X years, there will be found DNA or other biological material that could be subject to testing, period.
Well, I think it's a little bit more than that.
I don't know what else you can say.
It's a porous material. When blood or touch DNA, however you want to, there's
Go
a reason
between the
why
cracks, and it's
amici-
likely we can find it.
I'm sorry, Your
Because
Honor.
it's porous, maybe it's in the cracks, and that's why it's occult, and we can find it.
Absolutely.
So that's enough.
But then shouldn't they also, one of the advantages to the defendant of having that expert opinion is not waiving something like touch DNA. So it's to his benefit as well that they know the whole scope of the what screening is available and then what tests are available and what order they should be done, so that if there is destructive testing, that there's not a loss of material to find out who, to confirm who the perpetrator is. Thank you, Your Honors.